This case concerned a development on a street called Woolcock Street in Townsville. Coincidentally, I drive along Woolcock Street most mornings on my way to the university. It's a pretty standard industrial strip, which was once the main road out of town heading towards Cairns. In 1987, plans were underway to build a warehouse and office building. The foundation of the building was designed by CDG Proprietary Limited, a firm of civil engineers. There was a dispute between the owners of the new building and CDG about the foundations, and ultimately the owners demanded that the foundations be built their way. In 1992, they sold the building to Woolcock St Investments. Soon after, structural defects in the building were identified. They were the result of the foundations settling into the land beneath them. Woolcock St Investments sued the original designers, presumably not knowing those designs hadn't actually been implemented. The question which came before the High Court was whether the designers of the foundations had a duty of care in negligence to protect all subsequent owners of the building from economic loss, or whether their duty was only to the original owner who engaged them. Precedent suggested that the key factor was vulnerability. Were the new purchasers vulnerable to any negligent work done by the original designer? A presumption had crept into the law that subsequent purchasers of residential houses were likely to be vulnerable, while subsequent purchasers of commercial premises were less likely to be vulnerable. In this case, the majority judges found that there were plenty of things that the new purchaser could have done in order to look after their own interests. Their honours said it is agreed that no warranty of freedom from defect was included in the contract by which the appellant bought the land, and that there was no assignment to the appellant of any rights which the vendor may have had against third parties in respect of any claim for defects in the building. In other words, the new owners could have taken legal steps to obtain an assignment of the right to sue the civil engineers. They didn't. The court also found that they could have had other inspections undertaken, but they didn't. Following Woolcock, negligence causing pure economic loss can still result in liability to subsequent purchasers, but only if they take the necessary steps to help themselves.